So let's talk about fail to provide offences, circumstances in which the police can ask you to provide a sample of breath, what happens if you refuse, what the sentencing is for fail to provide offences, and whether there are any defences that you can rely on in court as well. Feel free to comment on the video, please like, and if you want to subscribe, you're welcome to. Now, fail to provide is a really serious driving offence, and it's an offence that carries a mandatory driving disqualification if you're convicted. And that's why I spend a lot of time defending these kind of cases in magistrates' courts across the country, because the people that we defend don't want driving disqualifications, they don't want things like community service, they don't want to go to prison. So it is really important to consider whether you might have a defence to a fail to provide allegation, and if you do, how you go about pursuing that and what evidence you might need for court. So fail to provide is an offence that's contrary to section 7(6) of the Road Traffic Act. And if you've got a charge sheet in front of you that mentions you've been charged with failing to provide, then look at the wording of the charge quite closely and you'll see the words reasonable excuse. It will say, without reasonable excuse, you failed to provide. So what is reasonable excuse? Well, there's no one definition of reasonable excuse, but it's quite broadly defined. So it could be that there was some physical injury that prevented you from providing that specimen of breath. It might be a medical condition, for example, asthma or COPD or long COVID that we've seen a lot more of recently. But it might also be a mental issue of some kind, mental health, or panic, or anxiety, or depression, or learning difficulties in police custody, and that's why you weren't able to provide that specimen of breath. So you're only guilty of failing to provide if you don't have a reasonable excuse. And just because the police have charged you with the offence doesn't mean to say you are guilty, nor does it mean to say you haven't got a reasonable excuse defence to the allegation. Now, if you think you might have a reasonable excuse defence, like one that I mentioned earlier, then it's important, first of all, to seek legal advice, because a solicitor will be able to explain exactly what evidence that you might need to put forward in order to win the case based on that argument. The burden falls on the defendant, first of all, to establish an evidential basis in reasonable excuse cases. So let's take the obvious one, asthma, for example, and that's the reason why you couldn't provide a sample of breath. Now, unfortunately, you can't just take your inhaler to court, hold it up to the magistrates and say, look, your worships, I've got asthma, please don't convict me of fail to provide. For obvious reasons, they're going to need more than that. But you might need some medical evidence. It could be an expert report that you can produce after the arrest, once you've been released from police custody. It could be statements from family members and friends, or even just a local GP who can confirm that you suffer with asthma and that you've suffered with this condition, that you do use an inhaler, that you've got a prescription, for example. So you can present this evidence, and the burden falls on you to establish what's called an evidential basis. And once you've established that evidential basis, which the court are happy with, that's enough to demonstrate that you might have asthma, for example. It then becomes the prosecution's job to disprove it. So they must prove beyond all reasonable doubt that you don't have a condition that prevented you from providing that specimen of breath. And for obvious reasons, that can be very, very difficult, because whilst you might want to introduce expert evidence of some kind, the chance the prosecution relying on experts and psychologists and doctors and respiratory experts in these kind of cases is always unlikely. The long time I've been doing this, I've never seen those kind of reports put forward by the prosecution. And that's why I'll always make the point that whilst fail to provide offences are more serious in sentencing, the penalties tend to be harsher for fail to provide cases, they are sometimes a little bit easier to defend, because you don't have to prove beyond doubt or prove on a balance of probabilities that you've got this defence to the allegation. You only have to establish a basis of the defence, and it then becomes the prosecution's job to disprove it. So with the asthma example that I gave, you might want a medical record that goes back some time that shows that you were diagnosed with asthma, or it could be, if you've got no medical evidence, you don't always have to, an expert report that you can put together after being released from police custody, once you've got your court date, even after your court date, that will show that you have got a medical condition of some kind, asthma, for example. So it's not always too difficult to argue these kind of defences in a courtroom. But what happens if you don't have a reasonable excuse and you just point blank refused because you thought you might be over the legal limit or the police officer was annoying you and you didn't want to comply. Well, that doesn't mean to say that you are going to be convicted of failed to provide offences, even where there is no defence, even where there's no reasonable excuse. One other way of challenging an allegation like this is on procedure, police procedure, and the way you are processed both at the roadside but also at the police station as well. So first of all, turning to the roadside, if the stop or the arrest or the test at the roadside was unlawful, then the prosecution may decide for that reason not to pursue this case all the way through to court, because if the arrest was unlawful, that can be quite awkward and embarrassing for the police, and that might be one reason why the prosecution wouldn't choose to continue with the case. At the police station, there's really important procedures the police have to go through whenever they ask a person to provide a sample of breath. So it's never as simple as saying, will you give a sample of breath, and you then just refuse. They have to fill out a really important 25-page procedural document, what's known as an M.J. document. So it stands for the Manual Guidance for Drink Drive Pro Forma A, and that's a nationally approved police-issued style pro forma that's designed to guide the police officer through the breath procedure from start to finish, and it contains a long list of questions and requirements and warnings the police should give you before they ask you to provide that sample of breath. Now, if you refuse to give a sample of breath in police custody, in a strange way, that can sometimes stump the police. They don't really know what to do or how to react in that scenario, because of course most people that are taken to the police station for this reason will comply, they'll give a sample of breath, they'll cooperate, they'll do as they're told, and the police obviously prefer that. But if you refuse in police custody, sometimes the police believe, wrongly, that they don't therefore have to fill out all the paperwork, because of course all the paperwork relates to breath specimens, giving a sample of breath, blowing into that machine, and how you blow into that machine. But if the suspect is refusing, the police officer may think, well, I don't need to go through this paperwork because he's not going to give a sample of breath anyway. And that's where they go wrong. So if the procedure was not carried out correctly, if you weren't given all the important legal requirements, if you didn't see this 25-page document being filled out either in the breath test room or at the front desk, if you weren't taken into that room, and that can be a point in which you can challenge this allegation. And remember, it's for the police to prove, beyond all reasonable doubt, that the procedure was carried out in the right way. If it wasn't, it's usually case closed for the prosecution. Now, it might be worth trying to access things like CCTV or body-worn video. I'd also ask for a copy of that M.J. document. Again, if they've not got it, or the CCTV shows that the procedure was incorrect, you'd usually escape a conviction for an offence like this. If you were taken into the breath test room and you tried to blow into the breath machine, let's say you made a couple of attempts to blow into the machine, the officer claims that you weren't blowing hard enough, and that's the reason why you've been charged with failed to provide, there may also be another defence that you can argue. And this relates to the small mouthpiece that the officer must attach to the tube on the breathalyzer. You might remember the small white mouthpiece that the police officer asked you to blow into. And these have to be new, they're packaged separately for hygiene reasons, and the police officer, using the end of the wrapper, would usually push the mouthpiece onto the tube. Well, if you couldn't provide a sample of breath, then you may be able to argue that the mouthpiece was blocked or defective in some way. So if you think the reason why you couldn't provide that specimen is because the mouthpiece wasn't attached to the tube properly, let's say air was escaping around the mouthpiece and that's why the machine wouldn't register the breath, or if the mouthpiece was blocked or faulty in some way, in most of these cases, the police will fail to retain the mouthpiece because in drink driving cases, they don't have to. So in drink driving cases, they get into the habit of taking the mouthpiece off the device and just popping it into the bin next to the machine. In a failed to provide case, that evidence goes from being completely irrelevant to really critical, because it may be that there was a problem with the mouthpiece and that was why you couldn't provide that specimen. I remember a case I dealt with a few years back now. We had the CCTV that showed the suspect and the police officer in the breath test room. The suspect had tried a couple of times to blow into the machine, but the device wouldn't register, and the police officer informed him on camera, "You're going to be prosecuted for failed to provide." At that point, the police officer took the mouthpiece off the machine and just threw it into the bin next to the machine. He left the room, turned the lights off. About 30 seconds later, the police officer walked back into the room, flipped the lights back on, put his hand into the bin, a bit like a lucky dip, picked out a mouthpiece and then took that back to the front desk with him. And he was claiming that that was the mouthpiece that was used in our client's case. Now, of course, he couldn't be sure of that because there would have been other people's mouthpieces in that bin next to the machine, and the case then failed for that reason because the prosecution couldn't prove that the mouthpiece wasn't blocked or defective in some way. So if you did try and blow into the machine, that can be a really effective defence to use, and I'm happy to discuss exactly how we go about trying to argue that in court. Now, turning to sentencing, there's 3 brackets of sentencing for a fail to provide offence. If you look at the Magistrates Court sentencing guidelines, and you'll find a copy on our website, there's 3 brackets that you can be sentenced in. The magistrates will either sentence you in the first bracket, the second bracket, or the third bracket. And different brackets mean a slightly different sentence. So if your case is considered less serious, then you might be sentenced in the first bracket of sentencing. And that's where there's a honestly held but unreasonable excuse. A common example might be that you refuse until you speak to a solicitor. So you're not providing a sample of breath until you get the chance to speak to a solicitor. The police will always tell you, we're not going to delay the procedure to allow you to speak to a solicitor because obviously alcohol levels will drop during that time, and it might be an hour or so until a solicitor becomes available. But that might be what you would consider to be an honestly held reason for not providing, but it would be an unreasonable excuse. And so in the first bracket, that's around about a 12 to 18 month driving disqualification. And they will always give you the drink drive rehabilitation course, even for a failed to provide offence, providing you haven't done it previously. The second bracket of sentencing is where there's a deliberate refusal. So if you refuse to give a sample of breath, even if you made attempts to blow into the machine and the police may have considered those attempts not to be genuine, there might not be any evidence of alcohol consumption as such. They're not saying that you were heavily intoxicated, but you've not provided a sample on a lawful request by a police officer. You're sentenced in that second bracket of sentencing, and that's when you'll see a disqualification, probably in the region of 2 years, sometimes a little bit less, but also community service in that second bracket. 2 most common types of community service: unpaid work, so you carry out unpaid work within the community, or if you're not suitable for unpaid work, then it could be a tag on your ankle, what's called a curfew, a bit like house arrest. You can't leave your house between certain hours, usually hours of the night. If you're sentenced in the third bracket of sentencing, that's when it can become more problematic and certainly more serious, because in the third bracket of sentencing, that's when there's evidence of serious impairment, but also a deliberate refusal. Now, you may say there's no evidence of serious impairment, but it's what the police will tell the court. So witness statements, for example, may say, these are statements from police officers, that there was evidence of bad driving. Perhaps you were involved in a car accident, your eyes were glazed, your speech was slurred, you smelt of alcohol, you were unsteady on your feet. And these are also key words and phrases that the police will put in witness statements to try and make it sound like you were heavily intoxicated, you were drunk, and that's the reason why you didn't provide that specimen. So if we couple that with a deliberate refusal, then the starting point is usually a 29-month driving disqualification, so a long driving ban, but also 12 weeks in prison. And that's for a first-time offender. If you've got previous convictions, disqualifications can increase, and also the risk of a prison sentence. There are ways of mitigating to try and reduce the chance of you going to prison. We might ask for a suspended prison sentence instead, or community service. If you head over to our website on the How We Can Help You section and scroll down to mitigation, you'll find some useful tips on mitigation, and that might include things like character references putting forward to the court, and also a personal statement like a letter of apology. Now, hopefully it doesn't come to that in your case where you are being sentenced and there's a real risk of prison. And as I've mentioned earlier in the video, there are ways of defending these kind of cases. One other option that might be open to us is what's called a basis of plea, where we negotiate with the prosecution to reduce either the type of charge or the facts upon which you're sentenced. And there are certain circumstances, certain ways in which you can secure 10 penalty points even for failing to provide a specimen of breath. It doesn't apply in all cases, but we usually are able to talk the prosecution down to 10 points where the argument applies, and that means there's no driving disqualification, and also the risk of custody is greatly reduced as well if you're getting penalty points on your licence. If you'd like to hear more about how we get 10 points for fail to provide cases, then please get in contact with me. Always happy to give free initial advice over the phone. You'll find our contact details on our website. You can request a call back. If you prefer to comment on the video, I'm happy to respond to you in the comments. Please consider liking the video and subscribing as well.